So welcome everyone to our final seminar in the first part of our lecture series on resource struggles in international law. I'm Caitlin Murphy.
And I'm Julia Dem, and we're delighted to see you all here. Before introducing our speaker, we'd like to acknowledge that we're on Wurundjeri Woi land and pay our respects to their elders and recognise that sovereignty has never been ceded.
So as some background, this online lecture series seeks to foster interdisciplinary and historical discussions about how international law both shapes and is shaped by struggles over natural resources. So it explores how international law is used by different actors to assert their authority and power over resources and to secure access to natural resources in areas beyond national jurisdiction and within the territory of nation states, as well as how such efforts are contested and resisted. So our hope is that by better understanding how international law has enabled and promoted unsustainable and inequitable resource extraction, we can better navigate the current transition to a low carbon world and collectively build futures that are socially and ecologically just. But if you missed our previous lectures in the series, you can watch them on the website. I'll put a link in the chat. And additionally, Julia and Dr. Anna Saunders from the ANU are convening a reading group on the theme of making and unmaking natural resources. So that meets 10 a.m. on Tuesdays fortnightly. And there'll be some more detail in the chat as well.
So I'm delighted to introduce our speaker for today. Umut Özsu is a professor of law and legal studies at Carlton University. His research interests lie in public international law, the history and theory of international law, and Marxist critiques of law, rights, and the state. He's the author of Formalising Displacement, International Law and Population Transfer, published by OUP in 2015, and Completing Humanity, The International Law of Decolonization, 1960 to 1982, published by CUP in 2023. So over to you, Umut. Thanks so much for joining us.
Thank you so much, Julia and Caitlin, for the very kind invitation, which I greatly appreciate. I've been a fan of both of your work for some time, and Julia and I have in particular known each other for quite some time, actually going back to both of our graduate studies, I believe. So thank you very much for this. So at the outset, I would just sort of launch into things by explaining where I'm coming from in this respect. So my quasi-official identity is that of a Turkish Canadian, right? My hyphenated identity, as we like to put it in Canada. And among other things, that means that I've maintained for a number of years now an interest, scholarly, but otherwise as well, in the operations of Canadian mining corporations, mining companies, oftentimes based in the province of Ontario, where I live, who do great business, strip mining and destroying and hollowing out whole mountainsides, in some cases, in supposedly public protected lands, some of them actually national parks, at least officially, in Turkey. Northwestern Turkey, along the Aegean coast, and northeastern Turkey, and so on. And of course, all of that happens in close collaboration with Turkey's own corrupt authoritarians and comprador bourgeoisies. So, that's kind of where I'm coming from. Larger interests in regard to resource sovereignty, resource extraction, land grabbing, and the like. So, what I thought I would do today is just provide you with a bit of an overview of the book about which I'm going to be talking today. So this is a book that, as Julia very kindly noted a minute ago, was published by Cambridge University Press recently in 2023. And it's about the international law of decolonization, specifically in the 1960s and 70s. So I'd like to provide a bit of an overview of the aims and arguments of that book. And then go into a bit of a sort of closer examination of the 5 chapters that comprise the book, give you a bit of a sense, just at a sort of snapshot level of what I'm trying to do in each of those chapters, and then finally drill down into chapter 3, which is the chapter that specifically deals with resource sovereignty. So time permitting, I'm hoping I can cover some of that ground. So to begin with, on October 24th, 1945, when the UN Charter first entered into force, an estimated 750 million people, nearly a third of the world's total population, lived in territories under direct or indirect colonial rule. By the end of 1990, 30 years after it had adopted the landmark Declaration on the Granting of Independence to colonial countries and peoples, this number had cratered to a few million, and the UN General Assembly felt enough pride in its track record to celebrate the inception of, quote, an international decade for the eradication of colonialism. These decades continue to the present day. Today, roughly 70% of the world's population is descended from colonizers or colonial subjects, in many cases from both. The experiences of countless occupied territories, oppressed nations, unrecognized states, secessionist movements, and indigenous peoples, to say nothing of those struggling against ongoing neocolonialism, make it clear that colonialism has not come to an end, and that it certainly cannot be reduced in any way to the formal processes of decolonization coordinated by states and international organizations. But the fact remains that over 80 states gained their independence within a single generation after the Second World War, with most colonial territories thereby reconstituted as states possessed of de jure sovereignty. Fewer than 2 million now live in the 17 territories that continue to be designated as non-self-governing on the UN's admittedly incomplete and controversial list. How was it possible for a transformation on this scale to unfold so rapidly? What was international law's role in it? Decolonization as an historical process certainly did not arise ex nihilo after the Second World War. Its histories include the Haitian and Greek revolutions and the independence of settler states in the Americas during the late 18th and 19th centuries. Nor was decolonization ever limited spatially to Asia, Africa, Oceania, and the Caribbean. In Central and Eastern Europe, for example, new states were created after the Second World War, as they were after the dissolution of the German, Ottoman, Russian, and Austro-Hungarian empires 2 decades earlier. The very term decolonization, which seems to have first appeared in print in 19th century discussions of France's occupation of Algeria and the Mexican-American War, was popularized during the interwar period by German emigre economist Moritz Bonn, who translated his neologism Gegenkolonisation into English as a way of conceptualizing what he regarded as a long-term development stretching back to the American War of Independence. Yet the heyday of decolonization came after the establishment of the United Nations, an organization often distinguished from the League of Nations by its recognition of what one observer at the time called, quote, the need for accommodation in a revolutionary stage of transition. This was a time when nations and peoples the world over secured formal emancipation from colonial rule. It was also a time when many pushed to fashion a new and decolonized international law. The specific dynamics and mechanisms differed from time to time and place to place. The removal of direct imperial control was a different matter, for instance, from the termination of a protectorate arrangement. A peaceful transition, quote unquote, in one territory might well be complemented by rebellions and counterinsurgency operations in a neighboring territory. Some colonial powers welcomed withdrawal as a means of shrugging off increasingly burdensome legal, financial, and administrative responsibilities, as well as the prospect of enhanced migration. Others resorted to brutal violence to suppress independence movements, as well as related protests and uprisings. So my book, Completing Humanity, documents the rapid rise and even more rapid fall of the most sustained attempt to decolonize international law ever undertaken. It commences in 1960, the year of the Decolonization Resolution, and it concludes in 1982 with the close of the Third UN Conference on the Law of the Sea and the onset of the Latin American debt crisis. The post-war push for decolonization began in the late 1940s and 50s, unfolding alongside a boom in development planning. But its political and economic consequences made their force felt on the plane of international law most fully during the 1960s and 70s. Growth in the per capita income of many developing countries slowed during the 1950s and 1960s, and the UN designated the 60s, 70s, and 80s as, quote, development decades. Formed in 1964, the year after the General Assembly adopted the Declaration on the Elimination of All Forms of Racial Discrimination, the UN Conference on Trade and Development, UNCTAD, became an important venue for discussions about economic development, particularly in regard to problems of what was called at the time unequal exchange, the long-term downward trend in the price of primary commodities, especially those produced in peripheral states, relative to the price of manufactured goods. By the mid-1970s, though, the post-war cycle of global economic expansion had sputtered to an end after years of declining rates of profit for many US and other firms, hard on the heels of the effective demise of the Bretton Woods monetary order following Richard Nixon's decision to take the dollar off the gold standard in late 1971, and the first of the decade's two major oil crises in 1973-74. The second major oil crisis would come in 1979, instigated in no small part by the Iranian Revolution. Building on deals they had struck with trade unions and working class movements during the interwar period, the national and transnational capitalist classes of the post-war North Atlantic had entrenched broadly Keynesian models of counter-cyclical demand management, partly through a significant expansion in the state's authority and capacity to provide social services. This had stabilized capitalist social relations in most industrialized countries, raising wages, employment levels, and rates of profit from the late 40s through the mid-60s, the core of what is still often regarded as a golden age for global capitalism. By the 1970s, however, competition-induced overproduction in the US and the introduction into its markets of goods from Western Europe and East Asia, particularly Japan and West Germany, increased pressure on US corporations and state institutions to weaken organized labor, drive down wages for domestic workers, jettison high-cost lines of production, relocate manufacturing abroad, and deregulate the financial sector. These developments exposed the contradictions in the post-war class compromise. Brought together through open distaste for Keynesian managerial techniques and a commitment to the price mechanism, neoliberals like Friedrich Hayek and Milton Friedman came to enjoy greater power at this juncture, jockeying for influence with socialists and partisans of reform packages like the New International Economic Order, the NIEO, in a contest to reconfigure the world economy. A tumultuous tide of historical and political developments roiled these shifting forces. The Vietnam War, India's annexation of Goa, Daman, and Diu, the Soviet invasion of Afghanistan, colonial wars in Portuguese Angola, Guinea, and Mozambique, the 1967 and 1973 Arab-Israeli wars, conflicts and massacres in Cambodia, Ethiopia, Indonesia, Lebanon, Nigeria, and Pakistan, and a large number of national liberation movements that did not always prove amenable to tidy legal distinctions between international and non-international armed conflicts. These were the years of second-wave feminism and the space race, the Soweto uprising and the Iranian Revolution, the 1975 Helsinki Accords and the strategic arms limitation talks, the measles vaccine, and the 1972-75 worldwide food crisis. The normalization of neoliberal models of legal and economic reform, first in Europe and the US and then elsewhere, went hand in hand with the operational breakthrough, as some have called it, Samuel Moyn in particular, of transatlantic human rights organizations, devoted in the first instance to combating torture and defending prisoners of conscience. It was in this rapidly changing context that the last major waves of decolonization unfolded. Driven to achieve and reinforce their sovereignty and independence, states struggling with legacies of uneven colonial era development and often bundled together in a nominally uniform third world. The term third world is generally traced to a 1952 article by French social scientist Alfred Sauvy, began to organize themselves on the international legal plane. They did so in significant part through the non-aligned movement and the Group of 77, formed in 1961 and 64, respectively. They also worked through UN bodies like UNCTAD, also established in 1964, and also the General Assembly, particularly its fourth committee, responsible for considering special political and decolonization-related issues, and its sixth committee, responsible for considering legal matters and producing draft treaties. Some of the new states, as they were called, quote-unquote new states, identified first and foremost as either capitalist or socialist, with different interpretations of those terms in the offering. The majority, though, elected to position themselves as non-aligned or neutralist. Non-aligned was a term that Nehru had used in the late 1940s and that began to enjoy widespread popularity during the 1960s, often being used interchangeably with older and explicitly geographical expressions like Afro-Asian. As the debates of the 1960s gained steam, the ideological troika of capitalism, socialism, and non-alignment, or neutralism, gained increased visibility, circulating alongside post-war distinctions between developed and developing states. Now, the push to reconstitute international law so that it might accommodate these changes and become a force of economic and political emancipation came to the fore powerfully during this period, finding expression in a kind of dual strategy. So on the one hand, right, the first prong of this dual strategy, as it were, on the one hand, jurists and diplomats from the predominantly non-aligned new states sought to conserve those elements of the international legal system generated after the Second World War and constitutionalized in the UN Charter that underscored the foundational status of sovereignty, non-intervention, and territorial integrity. The goal here was to harness international law's normative and ideological appeal in order to minimize foreign interference and support state-building projects designed to produce rapid and sustained socioeconomic transformation. Typically supported by their counterparts from socialist states, third world lawyers and diplomats defended those elements of international law they deemed useful for the achievement and consolidation of national sovereignty. State forms inherited from colonial rule or adapted from broadly European models, and the legal frameworks that formalized and legitimated them, were not to be cast aside so much as revamped, and in some cases, partly radicalized, with a view to augmenting, among other things, control of natural resources. Quote, perhaps it may even be said to be a matter of surprise that so much respect has been shown for the traditions of Western Europe, end quote, scoffed one US international law specialist in 1966, turning his conceit into outright hostility by adding that this remained the case, quote, apart from occasional psychopathic reactions that relate rather to matters of policy than of general international law, end quote. Such arrogance aside, it was hard to deny that the further universalization of international law, even in substantially transformed form, facilitated the further universalization of both European state structures and the capitalist world economy to which they were integral. International law's expansion and development was at root a reflection of capitalism's own expansion and development. Now, that's the first prong of this dual strategy. There's a second prong. So on the other hand, those who gave legal voice to the third world also underscored shared experiences of colonial and semi-colonial domination. They did so in order to establish collaborative institutions premised on shared need and mutual benefit. However committed they may have been to safeguarding their newfound sovereignty, those governing the world's newest states were keenly aware of their institutional limitations and economic dependence on the very powers from which they had liberated themselves. Most believed that cultivating trade partnerships, attracting foreign investment, consolidating political and military alliances, and fostering regional organizations with powers of functional coordination were all central to their security and prosperity, even their survival. Julius Nyerere, the first prime minister and president of independent Tanganyika, a long-time president of its successor Tanzania, was widely influential for his vision of Ujamaa, a cooperative society led by a one-party state that prioritizes rural development, harnessing key industries and natural resources to this end, and in which collective ownership is instituted through the villagization, as he put it, of production. Notably, though, even Nyerere merged this commitment to national sovereignty with a broader commitment to building a new international order. Nyerere is widely known for his dedication to the concept of self-reliance, the view that is that, as he put it, quote, a country or a village or a community cannot be developed, it can only develop itself. But, this is important, he also affirmed the need for developing states and peoples to forge a common front on the model of an international trade union, admitting that prioritization of political and economic independence did not reduce their need for foreign aid, technical assistance, and capital investment. Most third world jurists and diplomats towed a similar line. They defended the developmental state as an engine of social transformation. At the same time, though, they were active participants in transnational and intergovernmental networks seeking to accelerate international law's own transformation. Cutting across social, geopolitical, and ideological lines, the third world's international lawyers frequently found themselves supporting mechanisms of interdependence that complicated their adherence to state sovereignty. Okay, all this brings me to a kind of blow-by-blow, chapter-by-chapter type of account of what I'm trying to do in the book. So I'm going to now run through the 5 chapters that comprise the book, and then really focus on chapter 3, which again is the chapter on resource sovereignty. So my book, Completing Humanity, is a socio-historical analysis of an international legal field in transition. Post-war decolonization breathed legal life into self-determination, spawned the development of new conceptions of resource sovereignty, and led to doctrinal innovations like jus cogens and the common heritage of mankind, or humanity concept. Far from going by the wayside or entering a period of protracted decline, as some have suggested, international law expanded rapidly and remarkably during the long 1970s. So chapter 1 of my book focuses on collective self-determination. It does so by analyzing the negotiations for the 1970 Friendly Relations Declaration, the high watermark of efforts by socialist and non-aligned states to win support for an expansive interpretation of national self-determination. As a cornerstone of the effort to forge a new international law, the concept of self-determination attracted an extraordinarily high degree of interest after the Second World War. Lawyers and diplomats from the global north typically argued that the right to self-determination could be exercised in a number of different ways, from reconstitution into an independent sovereign state to loose association or confederation. They also contended that self-determination, understood as a human right, could be secured through adequate political and legal recognition within existing states. It did not necessarily require secession or outright independence. By contrast, those speaking on behalf of the states and peoples of Asia, Africa, and other zones of decolonization generally frame self-determination in broader, more capacious terms, as a right to economic, no less than political sovereignty. Arguing that formal independence meant little if newly sovereign states remained hampered by earlier arrangements, they called for an international redistribution of rights and resources, which they saw as the realization of self-determination's promise. They also stressed that the right to self-determination permitted armed struggle against colonial and occupying powers, contemplating provision of military and other forms of assistance for that purpose. Crafted through close engagement with these and other arguments, the 1970 resolution, the Friendly Relations Declaration, specifically that resolution's fifth principle, so has 7 different principles. The fifth principle is the one that's focused on self-determination. That resolution formalized an unsteady provisional compromise between these two approaches, encouraging self-determination, but never so far as to destabilize what was already a fragile interstate system undergoing extensive reconfiguration. So that's chapter 1. Chapter 2 concerns the concept of jus cogens. It examines the process through which the concept of jus cogens was introduced into international law during the 1968-69 Vienna Conference on the Law of Treaties, the first large-scale treaty-making conference involving a significant number of new states. The 1969 Vienna Convention on the Law of Treaties, the conference's final product, recognized jus cogens by endorsing the view that some rules of international law command universal authority and application. Formerly limited for the most part to cases of piracy, slavery, and the slave trade, jus cogens as an idea now found expression in Article 53 of the Vienna Convention, which declared that, quote, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted, end quote. And of course, it didn't specify exactly which norms counted as such. But the negotiations whereby jus cogens entered into the law of treaties were marked by wide-ranging debates about the nature and limits of the treaty-making power, and ultimately about the basic structure and orientation of international law more generally. On the one hand, were lawyers and diplomats from socialist and non-aligned states for whom the concept of jus cogens was potentially useful as a means of undercutting the legality of unequal treaties, colonial concession agreements, and other substantively unjust instruments. On the other hand, were lawyers and diplomats from leading industrialized countries who were committed to upholding the traditional principle of pacta sunt servanda, the sanctity of compacts, and also deeply skeptical of any attempt to introduce a nebulous spectrum in which a select group of legal rules would have controlling authority over all others. As the most abstract of all abstractions imagined on behalf of decolonization's international law, the meaning and scope of jus cogens was thus contested from the very outset. For Taslim Elias, one of the leading international lawyers and judges of his generation, a key player in the Vienna negotiations, the Vienna Convention was to be celebrated for proclaiming, quote, a new universal principle, a new public order for the moral guidance of states in their future treaty relations, end quote. Of course, as we all know, no such new public order ever materialized, but this was certainly not for lack of effort on the part of jus cogens' partisans and enthusiasts. Now, chapter 3 is the one about which I will talk at greater length after running through all of these chapters. But chapter 3 examines the concept of permanent sovereignty over natural resources, as it was articulated in the NIEO, the New International Economic Order project, and the debates that engendered that project. Comprising the core of the NIEO program was a call for enhanced aid, debt relief, and technology transfer, as well as the establishment of a specific international right to development, stabilization of primary commodity prices, the normalization of preferential and non-reciprocal treatment for developing states, and the institution and mechanisms of regulatory oversight in regard to foreign investors and multinational corporations. But arguably, its most significant element was the push to consolidate the legal status of the idea of permanent sovereignty over natural resources. This idea rose to prominence in UN discourse in 1952 on the back of a series of nationalizations, running from Argentina to Iran and presenting itself on both sides of the English Channel in Europe. Among other things, its champions argued that ownership and control of the natural resources of the relevant territory is an essential and necessary element of statehood, one that involves the right to nationalize foreign-held property in addition to pursuing tactics like acquiring majority interests in corporate subsidiaries or requiring them to hire nationals of the host state. By contrast, those opposed to strong formulations of resource sovereignty contended that no principle could be said to entail rights to expropriate or nationalize the assets of foreign investors without compensation. They also insisted that the quantity of such compensation should be determined by international law or through international arbitration in the event of disagreement. Most aspects of the NIEO program, including resource sovereignty, had been debated for some time prior to the 1970s, partly during broader discussions of neocolonialism, uneven development, and the question of a long-term deterioration in the terms of trade for commodity producers within UNCTAD, where international lawyers like Georges Abissab mingled frequently with revolutionaries like Che Guevara. Yet, it was only in 1974 that the project was formalized in a set of General Assembly resolutions. The program was largely the expression of a desire on the part of political and legal elites in the global South to renegotiate their roles in the world capitalist system, reforming rather than repudiating the existing international order. Even so, it was never fully implemented. Those demands that saw the light of legal day being diluted in a tortuously tedious process marked by circular negotiations and protracted delays. By 1982, the NIEO was effectively dead. The outbreak of the Latin American debt crisis, the consolidation of neoliberal policymaking in Washington and London, and the normalization of structural adjustment in lending to developing countries all combined to sound its death knell. Now, chapter 4, to some degree, builds on this chapter on resource sovereignty, chapter 3, by considering debates about the concept of common heritage of mankind, or common heritage of humanity, as we now call it, during the 1973 to 1982 UN Conference on the Law of the Sea. Once Harry Truman proclaimed U.S. authority over the resources of the continental shelf's seabed near its coast in September 1945, only a few weeks after Japanese officials surrendered aboard the USS Missouri, many Latin American and other countries began to advance jurisdictional claims of their own over ever larger portions of the world's oceans, issuing declarations or adopting domestic legislation to that effect. This phenomenon of creeping jurisdiction, as international lawyers at the time called it, raised the possibility of an unregulated and destabilizing scramble for maritime rights and resources and territories, culminating in what was often described as a steady and irreversible enclosure of the oceanic commons. It also lent additional urgency to developing countries' calls for a new and more comprehensive law of the sea treaty that would reflect their own rights claims. The result was a series of complex and fractious negotiations with 11 rounds of bargaining stretching across 9 long and acrimonious years. At the center of the negotiations was the question of how the deep seabed and its resources were to be managed, and what precisely it might mean to claim that they fell within the common heritage of mankind. Group of 77 states sought an international organization authorized to manage the deep seabed's resources directly, oversee its exploration and exploitation, and coordinate the global distribution of resulting benefits. By contrast, industrialized maritime states proposed a licensing system in which states and corporations would be granted concessions to operate in the international zone, with any new institution being confined to largely administrative functions. Ultimately, common heritage rhetoric proved central to the treaty that was crafted through these negotiations. Article 153 of the treaty legalized a parallel or public-private system of deep seabed mining. Activities in what the treaty termed the area may be carried out either by an organ of the International Seabed Authority, which the treaty established, or by states and firms to which this authority awards contracts. This solution or this resolution had the effect of ensuring that the ocean floor's resources would be controlled to a significant degree by those with financial wealth and technological means. Chapter 5, which is the final chapter of the book, focuses on the debates about development human rights, and basic needs that defined much of the campaign to craft a decolonized international law during the late 1970s and early 1980s. In particular, it considers the emergence of the international right to development and the relation between international human rights on the one hand and poverty reduction strategies like the basic needs approach in NIO-related discussions on the other hand. And it does that against the background of the rise of neoliberalism and organized human rights movements during the 70s and early 80s. In particular, what I focus on is are two reports produced by the North-South Commission, as it was called, a commission that was chaired by former West German Chancellor Willy Brandt. Building on elements of the NIEO, this commission, the Brandt Commission, recommended increased aid, lending, debt relief, investment, technology transfer, and a variety of other measures to further growth and satisfy basic needs in the global South. These measures would, in turn, members of the commission thought, help to slow inflation and reduce unemployment in the global North. Despite its overarching commitment to a renewed form of global Keynesianism, the Brandt Commission expounded a broadly rights-friendly approach to development that absorbed many of the neoliberal assumptions then on the rise. Its proposals included, for example, greater liberalization of international trade, expansion of markets and market institutions in developing countries, and fiscal discipline coordinated with the assistance of international financial institutions. These proposals were defended partly through appeals to the rights and dignity of human beings. Considered alongside contemporaneous debates about development and human rights, particularly the World Bank-supported notion of prioritizing basic needs for poverty reduction purposes, the Brandt Commission's published reports, the reports were published in 1980 and 1983 respectively, provide an entryway into the contradictions of the North-South divide that shaped the failed project of decolonizing international law. As Georges Avissab noted in 1980, there had been a movement, quote, in diplomatic language from the label backward, which was still in use in the immediate aftermath of the Second World War, via underdeveloped, to the current and rather hypocritical one of developing countries. He was writing again in 1980, end quote. The push to work up an international right to development reflected an attempt on the part of states in Africa, Asia, Latin America, and elsewhere to harness one of the era's defining political metonyms for the purpose of liberating international law from its past. When Ronald Reagan and Margaret Thatcher dismissed famously or notoriously the Brandt Commission's recommendations at the North-South Summit held in Cancun in October 1981, that moment signaled the end of the struggle to cultivate international law development that would live up to the ideal of an international law of decolonization. Now, just to conclude, and I realize that I'm pressing on the time, so I don't want to, take up too much more time, but I do want to, as promised, sort of drill down into chapter 3, which again is that chapter on the permanent sovereignty over natural resources debates. Just to sort of summarize what I'm trying to do in that chapter, I can say the following. Various models of resource sovereignty, including the idea of international rights to expropriate the assets of foreign investors, had, as I noted earlier, begun to gain traction in legal and diplomatic circles after 1945. The right of permanent sovereignty over natural resources figured in a series of General Assembly resolutions beginning in the early 1950s and reaching its first pinnacle in the 1962 Declaration on Permanent Sovereignty over Natural Resources, which recognized a limited right to nationalization with, quote, appropriate compensation, end quote, for reasons of, and I'm quoting, public utility, security, or the national interest, end quote. And that amount was to be determined on the basis of domestic law. And also, in addition to domestic law, importantly, in accordance with international law, as the resolution put it. Resource sovereignty was also central to most of the debates that unfolded in UNCTAD and at meetings of the non-aligned movement in Group of 77 during the late 1960s and early 70s. Yet, it was only, as I mentioned earlier, in 1974 that the NIEO, with permanent resource sovereignty as one of its key pillars, emerged as a legally formalized program to reform the world economy. Long frustrated by what even advocates of active collaboration with multinational corporations termed, quote, the obvious market manipulations of the Seven Sisters in the petroleum market. That's a quote from K. Venkata Raman. Many oil-producing countries had acquired increased leverage through nationalizations, not to mention the sharp rise in prices resulting from the embargo that Arab oil-producing states imposed on the United States and other consumer countries during and after the 1973 Arab-Israeli War. The immediate legal outcome of this drive to reconfigure the world economy through international law were three 1974 General Assembly resolutions: the Declaration on the Establishment of a New International Economic Order, the accompanying Program of Action on the Establishment of a New International Economic Order. Both of those were adopted on May Day, 1974, May 1st, and the Charter of Economic Rights and Duties of States, which was adopted later that year in December 1974. So this chapter, chapter 3, as I said, focuses on debates about the rights of states to nationalize the assets of foreign investors during the process of negotiating these three founding instruments of the NIEO. Nearly a decade before the General Assembly adopted these resolutions, some of those involved in the drafting of the Friendly Relations Declaration in the 1960s had argued that international rights and duties were correlated, such that no state could reasonably expect its rights to be respected if it did not also respect its own duties toward others. This relationship between sovereign rights and duties was key to the preparation of the NIEO instruments, especially in debates about resource sovereignty. In addition to urging investors to employ their nationals and minimize repatriation of profits, capital importing states frequently argued in these debates for a strong right of nationalization, recognized in domestic legislation, exercisable by domestic officials, and subject to legal interpretation solely by domestic courts. Capital exporting states, by contrast, typically opposed these moves, arguing that they undermined investor rights and were inimical to economic growth in host countries, which were likely to experience significant capital flight as a result. The NIO instruments of 1974 bolstered the former approach, the capital importing states approach, at the expense of the latter approach, the capital exporting states approach. The NIO instruments followed the 1962 resolution in recommending appropriate compensation in case of nationalization. But this time, they did so by recommending appropriate compensation as an unqualified right and with a quantity determined solely by the host state in accordance solely with its own domestic laws. Right? So that was the whole kicker. There was an additional difference from the 1962 resolution on permanent sovereignty over natural resources that the 1974 resolutions on resource sovereignty and the NIO really brought out. Yet, these instruments offered little in the way of an answer to the question of how the right to nationalize would actually further socially just redistributive projects within host states. Driven by the decades-old desire of socialist and third world states to ground formal independence and substantive economic and political sovereignty, and to safeguard the sovereignty by expanding relations of South-South cooperation, the NIO sought to reconfigure an interstate system whose basic coordinates it nevertheless still upheld, demanding little of ambition in regard to intrastate redistribution. The NIO's advocates did not aim to create a new world so much as they sought to secure more favorable terms for the South's ongoing absorption into a global system dominated largely by the North. So to really conclude, I won't get into the sort of weeds, the nitty-gritty of Chapter 3, but just to sort of highlight some of the things that are discussed in Chapter 3 that, if you are interested in sort of, reading the book or digging into that chapter, and if you do, want the book, just write to me and so on. Just to give you a sense of what I do in the chapter, let me just note that what I do is I provide a kind of history of post-Second World War expropriations, nationalizations, and also different legal formulae and standards for compensation that circulated at the time, particularly in the 60s and 70s. So the prompt, adequate, and effective payment formula for compensation in the event of nationalization, the fair and equitable treatment formula, how those formula were put into circulation, and so on. I discussed debates about unequal exchange and different models of economic growth and development in and beyond UNCTAD. I discussed the work of international lawyers who represented the interests of oil-producing countries, so that the list of such lawyers is long, but Algeria's Mohamed Bejawi, Mexico's Jorge Castaneda, the Palestinian Henry Katan, who set up shop in Lebanon and Syria as a oil and gas lawyer after the Nakba. Iraqi Hassan Zakaria, Lebanese Mohammed Muqabi, Libyan Mahmoud Maghribi, Christopher Dietrich's wonderful book, Oil Revolution, is particularly helpful in this regard. And just as a general note, I leaned on the work of many, many scholars, including Julia's work, and for the Law of the Sea chapter, for instance, Suabi Ranganathan's work, Kate Storr's work, and others. Further in this chapter, I look at the proceedings of the General Assembly's sixth special session, which took place in April and May 1974. And that is the session in which the NIO instruments, the three founding instruments of the NIO, were adopted. So I look at, in particular, Houari Boumedienne's address on April 10th, 1974, which really was one of the key sort of speeches that set the tone for that session, and so on and so forth. Boumedienne, of course, was the National Liberation Front, the Algerian National Liberation Front, one of its leaders during the national liberation struggle against French rule, and he was also one of the leaders of post-occupation Algeria, independent Algeria after 1962. I provide a close analysis of the drafts that were circulated by the Group of 77 and the Non-Aligned Movement for what would become the NIO Declaration, the NIO Program of Action, and the NIO Charter. I also, end here. I discuss developments within and beyond the UN system after the sixth special session. So that would include the North-South dialogue that was closely affiliated with the Paris-based Conference on International Economic Cooperation that really began in 1975, the effort to establish a common fund for commodities, an integrated program for commodities at the UN level. The common fund was really the kind of spearhead of that effort. The long and torturous history of the UN Commission on Transnational Corporations and the Center on Transnational Corporations that was affiliated with it. And I end that chapter by discussing critiques of the NIO from the neoconservative American right. So that would include Henry Kissinger, Daniel Patrick Moynihan, and many others, as well as the neo-Marxist global South-oriented left. And in particular, I concentrate there on the work of Samir Amin, Andre Gunder-Frank, Herb Addo, and others. So I'll end there. Apologies for going on so long.